In week one, we learned about the Senior Source, the Elder Financial Safety Center, fraud, scams, and exploitation of older adults. In week two, we heard from our financial experts, Steve and Debbie, about planning for retirement, about debt, and about credit. Last week, we talked about insurance and benefits. And then in today's class, we're going to hear again from Steve. He's going to be talking about end-of-life planning. We have a special guest speaker. Mike Bailey is a senior compliance officer with American First National Bank. They are a sponsor of the Elder Financial Safety Center and the Money Smart class. He is going to be talking about safe banking for seniors, and then he's also going to be talking about the durable power of attorney document and what you need to know before signing that. And then finally, we'll hear from Debbie, who's going to be talking about financial management for caregivers. And then we'll conclude with some end of class activities. Are there any questions before we begin today's class? All right, well then let me go ahead and bring up our financial counselor, Steve Benton. Steve.
Welcome. I told you that Debbie and I were going to be back after the second week, and so here we are. And Money Smart for Older Adults, week 4. Let's do a little review just quickly. The Senior Source, who we are, it's the one-stop shop in the Dallas area for older adults and their loved ones to navigate aging. And so we've been around for 62 plus years now, and that's who we are. And then a little review about the Elder Financial Safety Center. We're a collaboration of 3 organizations, the Senior Source, of course, the Dallas County Probate Court, and the Dallas County District Attorney's Office. And you see we all have different roles. We're in the prevention business where we do counseling and career services, basic needs, exploitation relief, financial literacy. That's part of this program today. And then the Dallas County Probate Court is in the protection business. They investigate guardians, making sure they're doing their job, and we actually remove unfit guardians. We do that every year. There's a number of those that need to be removed. And then finally, the district attorney's office when prosecution is necessary, and we make referrals over to those. And I don't know if you heard on that first week, one of our famous referrals was Doc Gallagher, the money doctor. And he was one of the first EFSC referrals over to our DA counterparts. And so we're a collaboration. We work together, and it's been ever since 2014. The Elder Financial Safety Center, we seek to help you avoid the dangers of financial uncertainty and exploitation. And so that's what this Money Smart of Older Adults is all about. This is my favorite cartoon since I didn't get to speak on scams and frauds. Basically, this is Gary Larson, The Far Side. Why are seniors so vulnerable to financial fraud and exploitation? You know, bummer of a birthmark, you know how. And seniors do have a target on their back because 70% of all the assets in this country are owned by baby boomers and above. And I think we talked a little bit about that 2 weeks ago. But what Willie Sutton said, why rob banks? Because that's where the money is, okay? And so seniors have the money and they want it. Aging and finances are coming into play a lot more because people are living longer. I think we talked about that. Here's some surprising statistics for you. 1 in 10 began to have cognitive difficulties by the age of 65, and it's 1 in 3 by 85. That 80s decade is the real problem one when people start to really have challenges in taking care of everything. And so that plays into the hands of what we're talking about today, is making sure you have your plans in place before it's too late, when you can't make those plans anymore. And so we'll talk a little bit about that. And then finally, this is something that may not have been covered that first week. There's a thing you can do with your financial accounts. It's called Trusted Contacts. And nearly all your banks and credit unions and your investment houses, your brokerage firms now have this, that you can fill out a form that you appoint somebody that if you start acting out of character, wanting to wire money overseas, like in a romance scam, and they know this is not your MO, you have given them permission to contact that person that you name They won't share any of your information. You know, they're not allowed to know your account value. They certainly can't trade or anything. But it may be a phone call saying, have you talked to your mom lately? She's doing some crazy things. She's withdrawn $10,000 at the window. And we've told her to watch out for scams, but she's insisting on doing it. So it just alerts that person that something may not be right at home. And so I'd really recommend that you go to your banks. And Mike, I'm sure you all have a form like that.
Yes.
And safe banking, that's really his bailiwick, and maybe he'll talk about that. But I really recommend that, doing that. All right, let's get to the subject at hand, end-of-life planning, financial safety and security as we age and beyond. When I first was asked to do this, to speak on end-your-life planning, I go, no, it's end of life. Okay, so I didn't want to get into end-your-life planning, though we do encounter that sometimes with our demographic. But let me give you the caveat, the legal notification. I am not an attorney. The information presented here is not legal advice, is not a substitute for, and does not replace the advice or representation of a licensed attorney, of which Michael is one, right? See? Oh, I thought you were. Okay. So anyway, there's my alert to you. So let's get started. The biggest mistake we make in life is thinking we have time. You know, what's the old soap opera like? Sands through the hourglass, or the days of our lives. And so here we are getting toward the end. And I always ask that question, how much of that dash is left between your B and your D on your tombstone? And nobody knows. But we tend to procrastinate, and that's what we're about today, to get you interested in getting things done. You remember this picture if you're here on that second week, Plan Ahead for financial planning. It works again here at end-of-life planning. I won't go through all the quotes, but the Ben Franklin one, by failing to prepare, you're preparing to fail, okay? And if you put this off and don't document what your wishes are, don't memorialize them, then we're going to see what the consequences are. And we'll talk about those consequences today. All right, estate planning. You hear that term, and it's kind of scary. And you think of that big house on the hill with the white columns. That's an estate. And that doesn't sound like me. But every single person here in the room and everywhere has an estate. Because what an estate is, the basics, is how do you want your money, your property, and your physical body to be managed while you're still alive, okay, and you need some assistance, and after your death, okay? So it's fairly simple. It's all encompassing of all the assets that you own, your real properties, and actually your medical requirements and your body after death, all needs to be categorized, all right? So that's what estate planning is. Planning the decisions you make before you are no longer able to. And that's the trap that I see a lot of people get into, where they never made those decisions, and then cognitively they've gotten to the point where no attorney will actually execute it for them because we don't know if they're of right mind or something. So this is something that you've got to get taken care of. All right? And it's not just a will. People say, oh, I need a will. I need a will. What estate planning does is it adds legal forces to your wishes. And the two main things are your will, what you want of your instructions to be followed after you pass away, after your death. But then there's also the power of attorney, which Michael is going to get deeply involved with here shortly, appointing someone to make decisions for you when you need the help. So one of them is while you're alive, okay, power of attorney. You can have a medical power of attorney, a durable financial power of attorney, where you're not able to make good decisions for yourself anymore, and so you've appointed a trusted individual to make those decisions for you. And again, you know, I can get into all sorts of scary stories, but we'll save that till later. But the will is actually while you're still alive. So you've got to memorialize these documents. You can't just willy-nilly tell people, well, when I'm dead, I want you to have this. Well, that means nothing, actually. And we're going to talk about dying without a will. because what that is called is you die intestate. And it sounds like if you die without a will, everything goes to the state, but that's not what intestate means. It means exactly that you died without a will. And so there's state laws, every state is different, of a hierarchy of who's going to inherit your stuff, okay? And so they go through a pyramidal hierarchy. Well, does this person have a spouse? If the answer is no, then the next question is, well, does this person have children? And if the answer is no, then the next question is, are the parents still living of this individual? And so you see the hierarchy working its way down until you finally find somebody that's there to inherit your property, okay? And so each one of those levels has some tricky things in there, because is your spouse still alive? Well, you may have multiple spouses, and they had children brought into marriage. And so, but the state is very specific about who's going to get what. And so you end up, when you don't have a will, having a thing called affidavit of heirship, and you have to go through and find two witnesses that know the family and can actually attest that these are the people, all the people involved in the family, because you did not document your family and what needed to be done. So that's another incentive that you can't just do it willy-nilly. You got to, get the thing done, and so forth. And Debbie will probably just testify that. She and her husband are working through that right now, getting their final documents done. And you'll speak to it. Good. So these never operate in tandem. So look at these. There's a will and a power of attorney. Okay, the will is a sleeping document until you die. Okay, it has no power. The person that you've appointed as executor has no power until you die. Okay, until the court actually receives that will in and gives that person authority to follow through with your wishes. Okay, and so at the same time, the power of attorney, the moment you die, ceases to be effective. Okay, so these never operate in tandem. While you're alive, you have the power of attorney, this agent that you have appointed to make decisions for you, and the moment that you pass away, that agent is stripped of their power. Okay, and it may be the same individual. Okay, it may be the trusted son in the family that's both the named executor in the will, but he's got to take off his power of attorney hat, and he's got to go to the court and put on his executor hat or his administrator hat and get that authority. So these documents have two different authorities, never operating at the same time, simultaneously. So I passed out a handout, Estate Planning Basics. So if you'd get a copy of that in front of you, and we'll kind of go through that. We've already talked about estate planning, the process where individuals specify how money, property, and their physical body should be managed during life and after their death. So this is all about transitions. You're transitioning from life to death, or you're transitioning from cognitive ability to non-cognitive ability, okay, while you're still alive. And so the will is the basic planning document. And when you go get your will now, basically they're probably encouraging you to go ahead and get your power of attorneys done, your medical power of attorneys, your financial power of attorneys. Those are two different documents, okay? And Michael's going to spend a lot of time on the most dangerous one, and that is the financial power of attorney, okay? And then you will also get your what's called the living will. And it's really your medical decisions that you want, do not resuscitate and so forth, your Privacy Act, HIPAA notifications. So all of it kind of comes in a package now. And you're wise to get all of them done at once, okay? And so again, intestate, dying without having a will. And assets are distributed according to a hierarchy of the state laws. And again, if you haven't made known your final arrangements, again, it's willy-nilly, your children or whatever do whatever they want to, whether it's cremation, burial, or whatever. So you want to make your wishes be known and so forth. All right, and that executor administrator has to go into court and has to hold up their right hand and swear that they will follow the wishes that are contained in this document. So you have memorialized your wishes in a will. Here is what I want done. Here's what my beneficiaries. They always tell you, if you don't want anybody to have a part in your will, then name them specifically in the will as you have considered them and you have leaving them nothing, okay? when you leave that open, then it leaves a challenge that she just forgot about me. Okay. And so there's all sorts of things, and why we always encourage you to get a will. And lower income people, we have a free will clinic. How often, Carl? Once a quarter or so?
Yes.
Yeah, here at the Senior Source. And you can sign up for that. And we have pro bono lawyers, volunteers that come in and will do that will for you. Okay? So again, we talked about the power of attorney. There's two different types. Don't confuse the term. You know, people say, oh, I've got a power of attorney. I say, what are you talking about? Making medical decisions, or are you making financial decisions? Because they are different. And again, the trust factor is very, very important. Probably 61% of our cases are moms in memory care, and daughters got the power of attorney out spending all of her money. You know, they're misbehaving, and we have to get involved and stop it. So again, make sure that you have a trusted individual there. And I can't tell you how much conflict that you create among siblings by naming one, and the other two wonder why he's got a new Lexus on his driveway. And you know what he says when they ask him? He says, it's for me to know and you to find out later when I allow you to. And that's right, because you have empowered him with all power. Okay? So it's very critical to make sure that you trust the individual. There's a lot of transparency. If you have multiple siblings, you really want everybody in on what's going on. And I think Debbie's going to talk a little bit about that later on, of what you do in times with your family and so forth. So we've talked about a little bit of investment in bank account designations, that you have to have a lot of care there. Michael's going to speak to that. You know, do you want a person on your account or signing as signing authority? Are they owners on the account? Do they have the power of attorney? And it's very important that you get the right designation, and he'll talk about that. So let me move on. Avoiding probate. You hear people say all the time, you need to avoid probate like it's some disease. Probate is not a disease. It's a process that orderly executes the wishes of the person that has deceased. Okay? And so usually when you have the fight in probate court, it's because there's a lot of money at stake, and it's worth fighting for because it's a very expensive process. But probate itself is not. If things are pretty much cut and dry. You know, and when I lived in California for 10 years, you definitely wanted to have trust instead of wills, because the probate process took up to 2 years to get through. There was a line around the courthouse, and a very expensive process to get it done. But here in Texas, it's not that big of a deal. Make 2 court appearances, and I think the whole thing was $1,500. Okay, so on the big picture of things, it's not that much. So I'm going to tell you how to avoid probate. If you think, I don't want to spend $1,500, well, here's some techniques. Again, I'm not a lawyer, but these work. How many of you have payable upon death on your bank accounts and your brokerage accounts? Oh, there's a hand right there. Way to go. What that does is you sign a document saying, upon my death, I want my money to go to my son and daughter 50% apiece. And you document that, sign it, they put it in the file. And when you pass away, whoever the beneficiary is presents the death certificate to the bank. And guess what? They do exactly what you told them to do. They set up 2 new accounts, and they can do with the money what they want. You've instructed them to do that, so that bypasses probate. Even if your will said, I want all of my money to go to the SPCA, okay? If you have a payable upon death on your account, it does exactly what it has. The will has no power over that. So this escapes probate. It avoids probate, okay? So you can put that document in the bank's file, and maybe Michael will speak to some of that also. You can also do that with your home, okay? We have a lot of clients that they don't have many assets, but they have a home that's worth considerable amount of money now. And so you can do a transfer on death deed. And again, it's the same process. You say, upon my death, I want the deed transferred to this person or these 2 people. You file it with the county is what you do. It's a county record. And so again, it's a sleeping document that doesn't do anything until you pass away. And when you do, the death certificate's presented down there. The county clerk reaches into the file, pulls it out. Oh, she wanted the deed transferred to this person. And they do it. again, it goes outside of probate. Okay. And so if you've taken care of all your cash and that stuff and your investments, and you've taken care of your real estate, what's left? Okay. Well, if you had my mother-in-law's will, she had this piece of jewelry going to this person, and there was a bunch of mechanics in there that we had to actually get appraisals for jewelry, which was expensive and a hassle. But you can handle that with a letter. Put a letter together, give all the people in your family a copy of the letter, total transparency. This is my wishes, and so don't fight it. And so, again, you don't have to take that. So when you have all of that, the question is, why even go to court? Most wills are not even probated, okay? Because if you're a married couple, a he-she will, the first will is rarely in Texas ever probated because everything goes to the spouse, okay? Community property estate. It's that second one that sometimes has to get probated. And so if you've taken care of this as a surviving spouse, payable upon death, transfer on death deed, then you don't have that issue, okay? And you may not even have to probate that will. So a lot of wills never get to that point. So again, it's a pretty straightforward situation. How about your cars? Are you worried about your cars? Who's going to get your car? Some people are. That is a cool looking car. That's my high school car right there. There's a picture of it. When I was a senior in high school, I wish I still had it today, but I don't. But you can fill out a DMV form, VTR 121, and it's the exact same thing. Upon your death, they transfer the title over to who you appointed. Okay? So, and I mentioned jewelry, but people say all the time, but what about all my furniture? Well, frankly, nobody cares about your furniture, especially if it's old furniture and it's not from IKEA. This generation has no interest whatsoever. It's heavy, it's marble topped. They don't have any china to put in the cabinet anyway. And so people think their furniture is worth a lot, but when you sell it all in an estate sale, there's just not much there. So yeah, everybody's nodding their head, okay? So I'm gonna turn this over to Michael shortly, but I just wanted to speak to power of attorney. And again, that trust factor is so important. I always use this sword or shield because it can operate in two ways. It can be a shield to protect you when you are unable to make decisions any longer, but it can also stab you in the heart if that person isn't the right person. So, I don't want to scare you. 95% of the power of attorneys work out exactly like they're supposed to. There's transparency in the family and so forth, but it's a mess out there when it doesn't work. And unfortunately, there is no supervision. There's no agency that's in charge of the powers of attorney of the world. Once you get one operating, nobody ever hears about it until it goes south, okay? And things go bad. So I'll just tell you the one story. I promised you one story. When we first started the EFSC back in 2014, we had an elderly gentleman that never had any kids, and he was going to go through a series of 3 surgeries and all the rehab, going to rehab, coming back to the hospital and so forth. And so his big concern was, who's going to take care of my house, who's going to pay my utilities, and who's going to feed my dog? And so he gave a general durable financial power of attorney to his nephew, the only person that he had in contact with his family. And so when he got out after that, I think it was about a 3-month period, his house was gone, all of his investments gone, all of his money was gone, and nobody knows where the dog is. So much less where the nephew is. He's gone. And so he had given full power and authority, and that's what you're doing when you do a full general power of attorney. Michael's going to show you the boxes that you should not check. He should have said, he has the authority to pay my bills, okay? But certainly didn't have the authority to sell his house whatsoever. But that's a true story, really sad. So you can revoke it, and there's a method that you go through. You don't have to go to a lawyer to revoke it. You just tell the power of attorney, I'm revoking your power. It's good to hand them a letter at the same time. Then you got to go everywhere that person was using it, like Bank of America or wherever, and say, they're no longer my power of attorney, and they'll remove that from them. But you can remove a power of attorney once you get one in place, okay? And so with that, I got to finish my final slide here. The biggest enemy of estate planning is procrastination, okay? Procrastination. Everybody says, I need to do that. I need to do that. And you never do. Okay. You should be able to get this whole package done somewhere around $1,000. Okay. So that's all of these notifications, power of attorneys, and everything else. So if you don't have it and you have a little bit of a complexity that it's going to have to go to court, then I was trying to show you ways that you can avoid going to court. Okay. And with that, there's one more slide, and that's the one you saw last time. There's my information. I've left some business cards up here. Debbie's got hers up here also.
Thank you so much, Steve. Appreciate all your information and experience. And so let me just go ahead and introduce our next speaker. Again, he's a special guest today. Mike Bailey is Senior Compliance Officer with American First National Bank. He's passing out some merchandise or items from his organization. American First National Bank is a sponsor of the Elder Financial Safety Center and the Money Smart for Older Adults class. And Mike is here to talk about, first of all, safe banking practices, especially for seniors, the things that he and his colleagues see on an everyday basis. And then he's also going to touch upon the durable power of attorney document and what you should know, kind of the do's and don'ts before signing that over to another person. So without further ado, let me turn it over to Mike.
Good morning, everyone. How's it going? So as Carl mentioned, my name is Mike Bailey. I'm with American First National Bank. I serve as our bank's Chief Compliance Officer, so I'm responsible for making sure that we're in compliance with any state, federal laws, and regulations. I'm also responsible for community outreach, so we go out and do financial literacy in the community to different audiences. And so that's one of the reasons why I'm here today. In the interest of time, I'm going to cover two topics, safe banking and also power of attorneys. There's a lot of information related to safe banking. I'm going to hit some of the high points, and then I will talk about the POA in detail. If you have a cell phone, you want to make sure that you're also updating your cell phone as soon as any updates are pushed out to make sure, again, that you're protected and that no one will be able to go through and actually hack your phone. So again, just try and make sure that you set maybe automatic updates. So I know with Apple iOS devices, you can actually go through and set it so that it will automatically push out any updates that are sent from Apple. I'm sure the same thing, or there's something similar also for Microsoft. Another thing that you want to keep in mind as it relates to safe banking is to make sure that you keep your PIN, personal identification number, or your passwords in a secure location, and that you update those passwords on a regular basis. What I mean by regular would max 90 days that you are going through and changing your password so that it's not staying the same. That way it makes it much harder for a nefarious person to try and get access to, again, your accounts. You also want to make sure that you're using somewhat complex passwords so that they include special characters. They're of a certain length. So anything less than 8 characters would be considered higher risk because there's a higher likelihood that an algorithm created by a hacker would be able to go through and actually guess your password. You can write it down, but if you write it down, just make sure you're putting it in a safe place that only you would have access to it. Or come up with some type of passphrase to make it easier for you to remember the password. But I'm going to move on to the power of attorney. And I'm going to walk you guys through first an exercise of what I generally see day to day sometimes as it relates to power of attorney account abuse. So in your packet, if you will take out the materials, there should be 4 items. The very first item is a copy of a medical power of attorney. Again, we're not going to go over the medical power of attorney. We're going to cover the statutory durable power of attorney, which is related to financial matters, real estate, etc. So the two are separate. That's why I want to make sure that I included a copy of the medical POA so that you guys can make a distinction between the two. So we're going to start with this document. So if you will take out the one that says statutory durable power of attorney. So once everyone has it out, then we're going to go through an exercise. So we're going to say that you are going to take a 2-month cruise of the Mediterranean, and you're going to leave me, your son, in charge of your financial affairs while you're away. And so in order for you to do that, I need to be added to your account. So I'm not going to be added as a joint account holder. I'm going to be added as a power of attorney. So I'm going to act as your agent. So you're going to be considered the principal, and I'm going to be considered the agent. My duty is to act on your behalf. And so you've agreed. So I'm going to take all my moms down to the bank. We're going to sit in front of the new account representative and ask her if she can, or he, if they can generate a power of attorney for us. Most of your financial institutions have generic forms, and they can execute those at a branch location. So that's where we're at. So we're sitting across from the new account representative. They've printed out the form for us, and so now we're going to complete it. So midway through, you'll see a blank line. It should start with the letter I. Right after that I, if you will write your first name, just your first name only, because this is a legal document, so I want to make sure that we don't actually execute a legal document here today. So if you just write your first name on that line. And I have extra copies, so later, if you need a fresh copy, I'll give you another copy. Okay, and then next, on that second line, it's going to say who you are appointing as your agent. And so you can just put Mike in that field. So again, I come over every weekend. I am familiar with your financial affairs. I'm the best son ever. So who would be a perfect person to add as, again, your agent? Myself. So again, I want to make sure you're taken care of while you're away on your cruise. All right, next, if you will flip over to page 2. And on page 2, at the very top, you'll see letter J, then K, L, M, N. What I want you to do is initial next to O. Just write your first initial next to the letter O. All right, so there's some other stuff that we don't really need to complete. So the next areas, compensation, co-agents, gifts, special instructions. Next, if you will go over to page 3. So page 3 at the top, it says, unless you direct otherwise below, this power of attorney is effective immediately and will continue until it terminates. So we'll just leave that as is. And at the bottom of page 3, if you will just write your first name. All right, and once you've done that, if you flip over to page 4, the last step is for the new account representative to notarize the document, which is going to make it valid and legal. And that will be the last step. So after that, now I am authorized to act on your behalf. So I'll drop you off at the cruise terminal, and off you go, and I will handle your financial affairs for you while you are away. Is everyone okay with that? No questions? Okay. So this is what I see quite often, is that we'll have people come to our branch locations, execute these documents, and not really read through and understand the power that they're giving someone. So really, in this situation here, you gave me full control to act as if I were you. So I can open accounts in your name, I can close accounts, I can borrow money, I can do anything that you would do. You set no restrictions and you gave me full power. So that's why it's important to make sure, especially with these POAs, that you read the document first and then decide who you're going to sign as your agent and what authority that you'll give that person. So for myself, I read through the document multiple times before I fully understood it. So it took me at least, I would say, a good 3 times of fully reading through before I had a firm understanding of the power that this document has. Then once I understood the power, then I understood, okay, this is what I need to do in certain circumstances. So I could limit the amount of authority that I give someone. So if I only want them to act as it relates to banking and financial transactions, I can do that. So like, for example, on the very first page, under letter E, it'll say banking and other financial institution transactions. You could have just limited my authority to only banking and financial transactions. And that would have been the only things that I would have been able to do using this power of attorney. Additionally, you could limit it further. So for example, if you only want me to have access to one account, you could indicate then on page 2, at the very bottom, there is a special instructions area that allows you to further limit the authority that you're giving someone when you execute a POA. So what I'd like to do is just go over the document so that you can get a feel for it, and should you need to execute one in the future, you are somewhat familiar with the document. So at the very top, it gives the name of the document. So this is a statutory durable power of attorney. Statutory meaning that the language that's in this document is pulled directly from the Texas statute. It wasn't modified. They just took it out and added it to a document, and now you can take that document and then execute it through bank, or you can go to an attorney's office, etc. This is not the only type of power of attorney. They are different. So there could just be a general power of attorney, meaning that it would not be formatted in the way that this document is, but still would give the same authority or effect based on what your wishes are. This is considered just a statutory durable power of attorney. Durable meaning that it will remain in effect if you become disabled or incapacitated. So the very top is very broad, as it says here. It gives you details about the POA itself, meaning that it is not a medical power of attorney, that you, again, should read through the document, that you should seek legal competent advice should you need. So it gives a lot of good information at the top. It's bolded to bring that to your attention. The next section after the bolded area is going to give you information related to when the POA will cease to exist. And so generally there are 3 situations in which it would no longer be effective. And so that would be if you were to pass away, the POA is no longer effective. If your agent resigns or passes away, the POA would also no longer be effective. Or if a court assigns someone as guardian, in most cases, is going to override the POA and it would no longer be effective. Yes, ma'am.
What if the power of attorney is out of the country for an extended period of time? Should there be another power of attorney?
Good question. You can list more than one agent to act on your behalf. So you can list co-agents. And if you list co-agents, you would then indicate in the power of attorney if they are to act together or if they can act independently.
Do they each then fill out a form?
You can actually include it on the same POA. And so on page 2, if you wanted to assign more than one, under this middle page where it says special instructions applicable to co-agents, this is where you would indicate that you're going to have co-agents acting on your behalf, and you will indicate either each of my co-agents may act independently for me, or you would initial next to the second one where it says my co-agents may act for me only if the co-agents act jointly. So it's a determination that you would make. So, but again, these documents, a lot of power that you're giving someone to act on your behalf. So the next area, again, is going to be on page 1, gives you the different areas in which you're giving authority. So real property transactions, tangible personal property, stocks and bonds, etc. And it continues on to page 2. On down to your digital assets. So that would be like access over your social media accounts, your email, your online banking accounts. And so again, you would indicate if you want your agent to have that authority. The next section would be special instructions. And so again, there's going to be 2 areas in which you can initial. As it relates to compensation for your agent, if I am your agent and acting on your behalf, you could allow me compensation for, again, handling your financial affairs. Or you may indicate that, again, my agent will not get compensation, but I will pay for any expenses that they incur while they're out acting on my behalf. So again, that is an option. So if you don't, let's say, initial either area, then it's going to be assumed that your agent will get compensation or is entitled to compensation. The same thing would apply if you listed co-agents, which is the next section. If you did not indicate, let's say you didn't initial either, and you listed co-agents, then each agent will be able to act independently. So you would want to make sure that you indicate the choice that you want and not leave anything blank. We kind of briefly talked about the special instructions area. So again, this is the area where you can really limit the power and authority that you're giving someone. So in our exercise here today, I said you guys were going on a 2-month cruise. And so in this situation, what you would want to do is after that, if you're going to handle your own financial affairs, to have an expiration date. So who should you assign as your agent? So in this case, it was Mike, because Mike came over to your house every weekend. He was there anytime you needed him. And so generally you would think, okay, Mike may be the best person to assign. And sometimes that may be the case, sometimes maybe not. It just depends on other factors. So for example, if you need me access to your bank and financial affairs, then if I have charge-offs, bad credit, no experience in managing finances at all, then I may not be the best person to list as your agent for financial affairs. Or if you really trust me, you may indicate that you want me and someone else to act together to handle your financial affairs. So again, I may not be the best as it relates to understanding finances, but I'm still going to look out for your well-being above anything else. So it would be myself and another person who has that expertise. If you want to revoke the POA, what do you think you need to do in order to revoke the power of attorney? So let's say, for example, you executed it. We did not indicate a termination date on this POA, but now you're back, you're handling your own financial affairs. What should you do if you no longer want me to act on your behalf? So you would again notify myself, who's the agent, and then you would call anyone who you think may be relying on that POA and put them on notice that, again, it is no longer valid. And they may ask you to come down and sign something in writing. But by you placing that phone call, I would say most of your financial institutions we'll notate the account that Mike is no longer allowed to act on your behalf. This POA is no longer valid as of such and such date. As long as you are competent, you can do whatever you want because, again, you are the principal. And so you can revoke a POA at any point in time. You have full authority and you don't need anyone else's permission to do so.
So now I'm going to turn it over to Debbie Burkham, our financial coach with the Elder Financial Safety Center. And she's going to talk about financial management for caregivers. Debbie.
Good morning. Thank you, Carl. So do we have anyone in the room today that is a caregiver or has been a caregiver? So we see a few hands, yeah? All right, well, very good. Well, hopefully what I share today will be useful. If it's not useful to you, hopefully you will go out and share this with your friends, your neighbors, your family members who are in a position where at some point in time they may be finding themselves where they're providing care to a loved one. So we've talked some about these different types of financial caregivers already. Specifically today, you heard a lot about power of attorney as it pertains to financial matters. Another type of financial caregiver is known as a guardian. There's also a trustee, a representative payee, and a VA fiduciary. We'll kind of pass over the power of attorney since we've talked about that a lot today already. Guardian. So a guardianship is basically the person's rights to make decisions for themselves have been taken away by a court for whatever reason. They have been deemed unable to make decisions for themselves, and so that responsibility has now been turned over to someone who's appointed as their guardian. So there's a guardian of the person and guardian of the estate, and in this case we're speaking specifically about a guardian of the estate, someone who is managing the money, the financial affairs. We also have a trustee, which is another type of financial caregiver. So this would be a person who's appointed in a trust document to handle the financial matters of a trust. And so there are beneficiaries in the trust who are receiving the financial benefits of that trust, and it's the trustee's responsibility to make sure that that is handled properly and according to the wishes of the person who set up the trust. Then there's also a representative payee. Representative payee is a title that is, I guess, a title and a responsibility provided to a person who is managing Social Security funds on behalf of someone who no longer can manage their financial affairs. It does require a letter from a doctor, medical professional. That goes over to Social Security, and it takes a little bit of time, but once Social Security has deemed that the recipient of the Social Security funds can no longer manage those funds themselves, then the representative payee is then appointed. They receive the funds on the behalf of that beneficiary, and the representative payee manages those funds on the beneficiary's behalf. And then you have a VA fiduciary, which is very similar to the representative payee. But these funds now come from VA instead of Social Security. And here at the Senior Source, we do have in our money management program a representative payee and VA fiduciary part of our money management program. So This Senior Source has been appointed as a representative payee or a VA fiduciary for some of our clients. We receive those funds on their behalf, and we manage those funds. We make sure that their bills get paid. We make sure that they have spending money. And so that helps to protect their financial security. A lot of times a representative payee or VA fiduciary or guardian, trustee, power of attorney, those are things that can still be handled by family members. It doesn't have to be by an organization such as us. Most cases it's handled by a loved one. Okay, so caregiver financial security. This is not so much about how to manage someone else's money, but more about how to prepare yourself for becoming a caregiver and how to manage your finances maybe leading up to that point and beyond to protect your own financial security while you're in that caregiver role. So what are some things that you can do to protect your own financial security while you're also being a caregiver to a loved one? In some cases, if that level of care that is needed by your loved one doesn't require a lot of your time, you can continue to work. And if you are fortunate enough to work for a company that is flexible in allowing you the time that you need to do that, that's even better. But certainly being able to work and provide those caregiving responsibilities is kind of an ideal situation. You may be very tired at the end of the day, but it's probably the most ideal situation. Preparing for caregiving by building up your emergency fund. So putting some extra money aside so that if you can't continue to work or if you have to work reduced hours, you have an emergency fund that you can draw on should you need that. And so that's just one other way to kind of help prepare for that role and protect your financial security. I have listed on here improving your credit. Well, some of you may be thinking, how does credit matter when I'm in a caregiving role? Well, if you're not going to be working, or if you're going to be working reduced hours, there may be a time where you have to maybe supplement your income through some other measures, using a credit card, taking out a loan. What if perhaps the person that you're caring for cannot get into your vehicle, and that's going to be your primary way of transporting them to doctor's appointments and other things? You know, if you are used to riding in a nice little two-seater sports car and they need something that's a little bit bigger and a little bit higher off the ground, you may have to think about getting a different vehicle to transport them in, and you may have to finance it. So having a better credit to finance those needs helps you in the long run. Lower interest rates and gives you that ability to negotiate a little more. Or what if the person you're caring for and you live in two different places, and now you're going to need to combine households? That may mean that you're going to have to sell a home, buy a home, rent an apartment together, whatever that looks like. All of these things may rely on a credit check at some point. Prioritizing your retirement savings. We hear a lot of times our younger kids, grandkids are starting out, well, I have plenty of time to save for retirement. I don't need to worry about that right now. We all know that the sooner you get started, it gives those funds a longer time to grow. And so by prioritizing your retirement savings and putting that money away now and taking advantage of your employer matching contributions, if you're fortunate to work for an employer who matches, gives that money extra time to grow. So that if you start off when you're in your 20s and your 30s and you get into a regular habit of putting that money aside, then by the time you're in your 50s, if that's when you find that you're going to be providing caregiving responsibilities, or your 60s, that money has had that time to grow, and you have a bigger nest egg that you can draw from if you need to. Hopefully you won't need to. If you are not in a position where you've been putting that money aside in your 20s or 30s and you don't get to until you're in your 40s, then start putting the maximum amount away if you can. By the time that you are in your 50s, if you can maximize that amount by taking advantage of the extra contributions that are allowed by the IRS, if your budget can handle that, then that would be recommended. Diversifying your investments. So early on, we think about maybe we can accept a little bit higher risk because we know there's going to be adjustments in the market. And so we can be a little bit more risky with our money while we're younger because we know it's going to come back. Even if we see a drop, it's going to come back. But maybe by the time you reach that caregiving role, that level of risk is no longer comfortable. And you need to put it someplace where you're sure that that money's going to be there. And you don't want to weather those changes in the market the way you have been. So that would be a good time to start looking at, do I want to keep these percentages in my portfolio the same, or do I want to start making adjustments, make it a little bit less risky? That way, when you are no longer in that caregiving role, if that should happen within a year, 2 years, or whatever, then you can go back and look at it again and decide if you want to start taking on a little bit more risk with those investments again. Passive income. What are some ways that you can generate some additional income that doesn't require a lot of time and effort? Perhaps you're an artist and you have some artwork that you could sell. Put it out there on some different sites, make it available. Perhaps you are that house you had, and now you're having combined households. Could you use one of those homes and rent it out to generate some additional income while you're not working or while you're working reduced hours? Do you have some talent where you could either tutor or maybe do some type of teaching music lessons or something? That's not really exactly passive, but it does give you some options for ways that you could generate some additional income that's not going to an office or to a work location, working a 9 to 5 every day. And if you are working, what about taking that family medical leave? Is that an option for you? Talk to your HR director and find out what is available under family medical leave for you. Perhaps you have a sick bank and you can draw from that for a period of time, and you don't have to be at work, but you can still get paid for it. And know that when that time is up, you're going to be able to come back and have a job. And then finally, another option is becoming a paid caregiver. So the unfortunate news is here that if you are caring for a spouse you cannot be a paid caregiver. But if you are the adult child of your parent, or if you are caring for a sibling, or if you're caring for your own child, perhaps you can become a caregiver, a paid caregiver. In order to do that, you would have to contact the Texas Department of Health and Human Services and find out what are the steps that I need to go through to get paid for caring for my loved one. Generally, there's some course that you will need to take. You'll have to become certified, and then you would become employed through an agency. So some tips for financial caregivers. This is for yourself. It can also be for your loved one, but you want to take inventory of your financial matters. Maybe make sure that you have it documented, have everything organized, where you know where to go if you need something. Make sure that you have documented your accounts, whether those are checking, savings, investment accounts, credit card accounts, anything like that, insurance, all of that. Set up bill pay schedule. So because you're going to be busy, you're going to be busy. So those important things, whether it's a mortgage, a rent, a car payment, insurance, a utility, something like that. If your budget can handle automatic payments on a bill pay schedule, then set up automatic payments. If not, somehow set reminders to yourself so that, it's the 1st of the month, I got to take care of this. Or it's the 15th of the month, I know that my car payment's coming due. Whatever the case may be, somehow you're going to have to be organized. Which leads us to record keeping. Make sure that you have good records, especially if you are communicating with medical professionals regarding the care of your loved one, or if you are talking with banks, financial institutions regarding financial matters for your loved one. Take good notes, date, time, who you spoke to, and make sure that you file that and keep it in a safe place. And same for yourself. Look at benefits. Guard your information. We heard from Michael today about how important it is to keep your passwords protected and to change your passwords, not just share your personal information or your loved one's personal information. So protect that with your life, just because identity theft is huge and it's real and it's not easy to recover from if you don't have a plan in place. And then seek help if you're not sure where to turn. You always have the senior source. You have Area Agency on Aging. You have attorneys that you may have access to. You may have your bank. And just finally, one thing I wanted to mention, if you have not discussed with your family members what your own wishes are for yourself towards your end of life, this is a great resource for you, the Conversation Starter Kit. They have a website, theconversationproject.org. They have a starter kit that you can print, and questions and answers in that kit will be very valuable to your loved ones if something should happen to you as well.
All right, well, that concludes the content for our class, for our course.